Let's look at the criminal law system for a second. Something happens to you, you rush to the Thana, you go there, you sit by a cop and you tell them, sir, this is what has happened. Ideal situation, which Lalita Kumari reiterates, but ideal situation is the person sitting there listens to you and weighs whatever you're saying in that tarazu to see whether it is a cognizable offense or a non-cognizable offense, right? In that tarazu, whatever weighs heavier either becomes an FIR or a criminal report. As you are aware that in a criminal report, the investigation now will only take place once the magistrate gives the go-ahead. There will be no arrest, etc., etc. But where there is a case where an FIR is to be made, in such a case, the police is duty-bound to register the FIR. Lalita Kumari says that you cannot even say that we don't have territorial jurisdiction. You will either cut a zero FIR and investigation will take place. The IU, after investigating the matter, is going to consolidate everything, put it in a file, take it to the magistrate and say that within the stipulated period of time, arresting, non-arresting, all of that is secondary. That 60 days period or 90 days period is that he will go ask the victim kya hua, perhaps go and find the object which are or documents which are a part of whatever has happened and put them all together, put it in a file, go to the magistrate and say, this is my investigation till now. I have taken this time to investigate the matter. This is what I think. Now, sir, what do you think? So basically, he files the charge sheet. The charge sheet is his report with everything underneath. And the judge then applies its judicial mind for the first time, takes cognizance. Cognizance is to see, not as a human being, but as a judge through the specs of judiciary, of law. And then is supposed to impart justice. How? To say, I think I have seen enough, call the accused. I see you haven't done your job. Investigate more. I see you have no case. Shut the case down. And in all the three scenarios, the IO works accordingly. So now the accused comes, then there is prosecution evidence, there is defense evidence, the entire circus. But the funny thing is that the largest stakeholder, the consumer of justice service system, is sitting in a corner and wondering what the hell is happening. What did the police uncle do? I have no idea. And he keeps going to the police uncle, and every time he goes to the police uncle says, "Acha chalo chai pila do," and sends him, "Sab theek hai, jao." So the largest stakeholder, which is the victim, is sitting in the corner, doesn't know what's happening, right? It is only in 1980s where in a particular case, the Supreme Court said, listen, if you're closing the case, I think it is only fair that we go and inform the victim. In our considered view, no case is made out, we are shutting it. And then allowing him to file a protest. Please don't shut this case. It is an important case and I will tell you why. And that's an exception to the rule that was brought in by a judgment of the Supreme Court. I mean, imagine that. We've discussed and we are all in agreement that the consumer, the largest stakeholder, is the victim. And victim has absolutely no role to play according to IPC, CRPC, Indian Evidence Act. He's sitting in the corner looking at the entire circus, perhaps not even allowed to enter the tent, right? The only time he's allowed to enter the tent is when they say, you have no case. And he's now supposed to now say, no, but I have a case. And now imagine for a second, and this is how I like to say, one of the services that for the charge that we give to the government every year is justice dispensation. Well, then you're the only consumer because we are all service providers at the end of the day. I am a service provider whose job is to be a solution provider. The prosecutor fairly squarely should not to represent the state. That is what they say, I'm to represent the state. No, his job is to help the judiciary or the judge to unearth the truth. Ideally, he is that filter between the investigating officer and the judge who filters information when it comes to the judge. And the filtration process to make sure that pure, uncorrupted, unadulterated information comes to the court. That's his real job, isn't it? Because the job of the IO is also not to catch the culprit. What is his job? To unearth the truth, to find out who really did it. And therefore, the filtering mechanism that the Supreme Court and the High Courts have put in are what? That the investigation shall be impartial, that it shall not be colored by your personal biases, you shall not be affected by the color, caste, whatever other filters that one has. And that is why, again, coming back to Lalita Kumari and various other judgments like that, the court said police is duty bound to register the FIR. Police cannot even say that I have investigated, no case is made out, because the investigation can only take place after the FIR registered.